To Supreme Court just dropped unanimous rulings that gun owners are calling huge victories, and buried inside those decisions is a bigger threat that most lawyers haven't even started talking about yet. Pause, stick with me, because what I'm about to explain could change how you carry, how you store, and even how you fill out a federal form from now on. Quick question before we go any further: are you subscribed to this channel? Because what I'm about to break down is the kind of legal update most gun owners never hear about until it's too late. Hit that subscribe button right now and turn on the bell so you don't miss the next one. Deal? Good, let's get into this. Let me set the stage. On June 18, 2026, the Supreme Court released its decision in a case called United States v. Hmani, 920. Every single justice agreed, and on June 25th, just 1 week later, they dropped another gun case called Wolford v. Lopez, 6-3. And these two decisions on the surface look like clear wins for gun owners, and they are. But here's the part nobody's talking about: the way the court wrote these opinions actually creates a bigger threat for ordinary citizens like you. And in a few minutes, I'm going to show you exactly what that threat looks like and what you can do to stay ahead of it. Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. Don't take my YouTube video to court. Got it? Good. First, let's talk about Hmani. You need to understand what this case was about, because the facts are wild. A guy named Ali Hemani lived in Texas. He owned a firearm at home for self-defense, totally legal in Texas. He also used marijuana. Now here's where it gets crazy. Under a federal law called 18 U.S. Section 922G3, it's been illegal since 1986 for any unlawful user of a controlled substance to possess a gun. The penalty: up to 15 years in federal prison. So Hmani got indicted under this law for the simple act of having a gun at home while being a marijuana user. He fought it, and the case made its way all the way to the Supreme Court. The court ruled unanimously that Section 922G3, as applied to him, violates the Second Amendment. Every justice agreed. That alone is huge. 920 on a gun case almost never happens. But here's what's even bigger than the win itself. The court didn't just say marijuana users can have guns. The court used what's called the Bruen test. That's the historical test the Supreme Court created back in the New York State Rifle and Pistol Association v. Bruen case. Under Bruen, the government has 2.2 historical laws from the 1800s that prove the modern law is consistent with what the founders intended, and in Hmani, the government tried to point to old habitual drunkard laws from the 1800s. They said those laws prove our founders were okay with disarming certain classes of people, but the court said no, the historical analogy doesn't work. Why? Because those old laws didn't apply to everyday users. They applied to people who were, quote, habitual drunkards, meaning people whose drinking had totally taken over their lives. Applying that same category to a regular marijuana user is not historically justified. That's the heart of the ruling. Now let me explain why this matters to you, even if you don't use marijuana, even if you don't use any illegal drug. This ruling reshapes the entire federal firearms landscape. Because Section 922G has 9 different subsections. 9, they ban gun ownership for felons, for people convicted of domestic violence, for people with certain mental health rulings, for illegal aliens, and more. And the government's lawyers have been using the same exact reasoning across all 9 subsections. If historical laws let them disarm one group, they argue, then they can disarm all groups. Hmani just punched a giant hole in that logic. The court said the history has to be specific. Just pointing to similar-looking laws from the past isn't enough. The government needs a real historical match, and that's where the bigger threat comes in. Here's the part that should worry you. Lower federal courts, the ones that handle most gun cases day to day, are now scrambling to figure out what Hmani means for the other 8 subsections. Some judges will apply it narrowly and only kill the marijuana ban. Other judges will apply it broadly and start striking down other parts of Section 922G. And here's the crazy part. Depending on which federal district you live in, you could have completely different answers too. The exact same question. Imagine you're filling out the federal form to buy a gun, the ATF Form 4473. It asks if you've ever been convicted of a felony. It asks about domestic violence. It asks about drug use. Now, after Hmani, some of those questions are legally murkier than they were a month ago. You answer wrong, and you're looking at federal perjury charges plus 10 years in prison. That's not a joke. That's the bigger threat hidden inside this win. And let me be clear about something. The Supreme Court did not say all drug users can have guns. They said the law can't be applied to a regular marijuana user the way it has been. There's still room for Congress to rewrite the statute. There's still room for prosecutors to charge people who are intoxicated while in possession of a gun. So don't go out and do something reckless thinking the courts have fully cleared the path. They're not there yet, but make no mistake. This is the first domino to fall, and the next ones are coming. Now let me shift gears to the second case, Wolford v. Lopez. This one is different but equally important. So Hawaii passed a law and California passed a similar one that basically said this. If you walk into any private business open to the public, your gun is automatically banned unless the owner puts up a sign saying you can carry. People called this the vampire rule because you had to be invited in to bring your gun, like a vampire needs an invitation to enter a home. Gun owners challenged it. They said the Second Amendment doesn't let a state flip the default from you can carry to you can't carry unless we say so, and they took it all the way to the Supreme Court. On June 25th, the court ruled 6-3 that Hawaii's vampire rule is unconstitutional. The court said you can't make concealed carry permit holders prove the property owner said yes. Instead, the default has to be that lawful carry is allowed. The owner's no has to come through a clear signpost or verbal request, not through silence or absence. Now, on its face, this is a massive win. Imagine you're traveling through Hawaii, you have a concealed carry permit from another state. Hawaii doesn't honor most out-of-state permits, so this didn't directly fix that problem. But for Hawaii residents with permits, you can now walk into a restaurant without obsessing over whether the owner quietly meant no guns. That's real. That matters. But again, here's the threat nobody's talking about. The bigger threat in Wolford isn't Hawaii. Hawaii lost. The bigger threat is what California knew. York, New Jersey, and other states are going to do next, because the Supreme Court just told those states they can't use the default no trick on private property. So what will they do? They'll expand the list of what they call sensitive places. Sensitive places is the legal term for locations where the government can restrict guns even for people with permits, schools, courthouses, polling places. The Supreme Court has long allowed those, but under this court's Bruen reasoning, the government has to show historical support for calling any new place a sensitive place. And here's the threat. State legislatures are going to start declaring wide swaths of public life sensitive, public parks, public transit, outdoor festivals, whole city blocks around protests, anywhere a politician wants you disarmed, and they'll pull from vague historical sources to try to justify it. Some of these attempts will succeed. In lower courts, others will fail. The result? More lawsuits, more confusion, more ordinary citizens like you getting charged because they didn't know their local zoo just got declared a sensitive place. Let me walk you through a hypothetical example. To make this real, let's say you live in a big city. Your state legislature passes a new law declaring the entire public transit system, including the bus stops, the train platforms, and the 10 feet of sidewalk around every station a sensitive place where guns are banned. You've got a concealed carry permit. You legally carry every day. You walk by a train platform on your way to work. You don't even board a train. You just walk by it. A police officer stops you. He says you're within 10 feet of a sensitive place. He's not wrong about where you're standing, but the law is brand new. It just passed last month. Did you know about it? Probably not. Are you guilty? Maybe, maybe not. That's the bigger threat. Laws moving faster than your awareness. And this isn't hypothetical. After Wolford was decided, gun control groups immediately started pushing state legislatures to expand their sensitive places lists, every town for gun. Safety put out public statements calling the ruling narrow. They argued it doesn't prevent states from listing more places, and you can bet legislatures in deep blue states are already drafting bills right now. So if you carry, the lesson from this case isn't you can carry anywhere now. The lesson is you can carry in more places than before, but the rules are still shifting underneath your feet. Let me pull these two cases together now, because that's where the bigger threat becomes really clear. Hmani says the federal government can't disarm ordinary Americans based on weak historical analogies. Wolford says states can't use default rules to disarm you on private property. Both decisions expand your rights, but both decisions also create new uncertainty. New uncertainty about what federal prosecutors can charge you with. New uncertainty about where exactly you can and can't carry in your own state. And in the meantime, every local DA, every state attorney general, every county sheriff is making their own decisions about how to apply these rulings. Some will apply them broadly to protect you. Some will apply them narrowly to keep charging people like nothing changed, and the difference between those two outcomes is whether you walk free or you go to prison. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. I'm dead serious. Those 5 words matter more than anything else I've ever taught. Let me give you the practical takeaways now, because after everything I just said, you need to walk away with action steps, not just information. Action. Number 1. After Hmani, do not assume that having used marijuana in the past makes you safe to possess a gun. The ruling is narrow. Prosecutors are still charging cases, if you have any history with controlled substances. Talk to a lawyer in your state before you touch a firearm or fill out a 4473. Yes, even if it's marijuana legal in your state, marijuana. Federal law is what matters here, and federal law has not yet been rewritten until Congress acts or the Supreme Court goes further. You're still in a gray zone. Don't be a test case. Number 2. After Wolford, learn your state's current sensitive places list. Don't assume the list from a year ago is current. Google it. Check your state police website. Check your Attorney General's recent press releases. Many states are actively updating their lists right now in response to Wolford. The places you can carry today might be off limits tomorrow. That's how fast this is moving. Number 3. Carry your permit and your identification whenever you're carrying, always, every single time. If Hmani taught us anything, it's that paperwork mistakes can become federal charges. The same principle applies to every encounter. Make it impossible for a prosecutor to argue you didn't know the rules. Number 4. Join a firearms law update list in your state. Many states have Second Amendment advocacy organizations that send email or text alerts when courts issue new rulings or when new laws take effect. These groups are often faster than the mainstream news. They will tell you within hours when a new sensitive place is added, when a lower court strikes down part of your state's gun law, or when federal prosecutors change their charging policies. Number 5. Document everything. If you're carrying in a place you believe is legal, snap a photo of the entry sign, the absence of a sign, the date, the time, if you ever have to defend yourself legally. That documentation could be the difference between conviction and acquittal. Lawyers tell me this all the time. The clients who document are the clients who win. Let me hit you with the truth about why. I made this video. The gun rights community is celebrating Hmani and Wolford, and they should be. These are real wins. But if you only hear the celebration, you'll be caught flat-footed when the next wave of restrictions shows up. At your state house, the bigger threat isn't losing these cases. The bigger threat is winning them and then getting blindsided by the legal chaos that follows. That's what I'm trying to save you from. That's the whole point of this channel. Now, before I close out, I want to address the elephant in the room, because some of you are watching this in states where marijuana is fully legal recreationally. You're thinking, this doesn't affect me. I can have a gun. I smoke weed legally, and I get why you feel that way. But federal law still says marijuana is a Schedule I controlled substance. The Supreme Court has not changed that. What they said is that Section 922G3 can't be applied to a regular marijuana user the way it's been applied, but can't be applied and is fully repealed are not the same thing. The Department of Justice could still try narrower prosecutions. The ATF could still write new rules. Congress could rewrite the statute to be more focused on people who are actually intoxicated. We don't know yet, so don't gamble on the assumption that the gray area is gone. It's not. Let me also say this. Some of you might be thinking, why should I care? I don't use drugs. I don't live in Hawaii, because both of these cases set legal precedent that affects every gun case in America. Lower courts read Supreme Court decisions every single day. They apply the reasoning to 100 different fact patterns. The logic of Hmani that historical laws must be a real match, not just a rough analogy, is logic that can be used by defendants charged under other Section 922G categories. The logic of Wolford that default rules can't strip away Second Amendment rights is logic that will be cited in cases about transit, parks, sidewalks, and stadiums. You're affected even if your personal situation isn't directly covered by either case. That's how legal precedent works. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Seriously. This channel only stays free because of people like you hitting that button. Let me leave you with the takeaway. The Supreme Court wins just became law. Hmani struck down the federal ban on gun possession by marijuana users, at least as applied to regular users. Wolford struck down Hawaii's rule that made private property off limits by default. Both cases expanded your rights, but both cases also created new legal uncertainty, new gray areas, and new targets for state legislatures that want to restrict your carry. The bigger threat isn't the Supreme Court. The bigger threat is the chaos that follows these wins, and you walking into that chaos without knowing the new rules. Now you know the bigger threat. Now you know what to do about it. Don't be the person who celebrates the headlines but ignores the fine print. This information could literally expire with the next legislative session. Subscribe now, because the next video explains exactly what you need to do before your states new laws take effect. Let me close with this. I'm a lawyer. I've been doing this for a long time, and I can tell you the difference between a gun owner who knows the law and a gun owner who doesn't is usually about 10 years of prison time. That's not exaggeration. That's the federal sentencing guidelines. So please, please, do not take this stuff lightly. Don't carry without knowing your state's current laws. Don't fill out a 4,473 without understanding what's on it. Don't talk to police about your gun without knowing your rights. Every single one of those moments is a moment where the law can save you or destroy you. Pick the right side of that divide. Final reminder, this is educational information, not legal advice. Every state has different rules. Every situation has different facts. Always consult a licensed attorney in your state before making any decision based on what you've heard here. I'm trying to give